Welcome to today's video. Today we're taking a look at a basic copyright topic, and that's the DMCA Basics. So I'm Richard Chapo. I'm an attorney down in San Diego, California. I've been representing online businesses for about the past 20 years or so. So DMCA Basics, what are we talking about here? Well, the DMCA is a federal law in the United States. DMCA stands for Digital Millennium Copyright Act. You will no doubt be shocked, I say shocked, to learn it addresses copyright issues online. So we have to step back a little bit in time to get a grasp of what the DMCA is and the basics surrounding it. We're going to go back to around 1995. At this time, we had a very primitive version of the internet. Most people were accessing it through dial-up modems, which were basically call-in systems through your landline in your home. The process was very, very slow, as in poke your own eyes out slow. But nonetheless, governments and groups around the world were starting to realize that this internet thingy could actually become a long-term platform that would potentially radically change society. And the question was, how are we going to deal with legal issues in the online arena? And so groups were starting to contemplate that, and laws were going to be passed pretty quickly that would help try to build a foundation for the internet to grow. And so in 1995, we had one group in particular, the World Intellectual Property Organization, of which the United States is a member, was looking at the internet, particularly in relation to copyright issues, because it was becoming pretty apparent that copyright was going to be a big issue in the online arena. And so after much debate and discussion, WIPO actually issued some guidelines on copyright and suggested that the different countries, take those into account and perhaps should pass laws addressing copyright. And so that's how we got the DMCA. It was actually introduced to Congress and passed in 1998, and President Clinton signed it into law on, I believe, October 26th, 1998. And so we've had it ever since then, and it's worked out fairly well, though it does have some legitimate critics who've gone after it, but that really goes beyond the scope of this video. So when we talk about the basics of the DMCA, what are we talking about? Well, if you're here watching this, we're really probably going to be focusing on what we call the sweet immunity provision. It's also known as the safe harbor provision at Section 512C of the DMCA. Now, what this provision says is that an internet service provider cannot be found liable for monetary damages for copyright infringement claims based on content uploaded by a user. Now, that obviously is a rather large mouthful of vague terms. What it basically means is that if you have some kind of service online, that you cannot be held liable for copyright infringement for content that your users upload. So if we take a look at this video, I'm creating it, and my intention is to post it on YouTube. Well, if there's some aspect of this video that constitutes copyright infringement, say the little guy on the right here, let's pretend I swiped him off of some site and republished him without permission, well, technically that could be considered copyright infringement. Well, would I be held liable for that? Could I be held liable for that? Absolutely. I'm the one who committed the act. But what about YouTube? And under the DMCA, the answer is no. Section 512C is going to give them immunity because I'm a user of YouTube. I'm the one uploading the content. And Section 512 says that an internet service provider cannot be held liable essentially for the acts of the user in relation to copyright infringement. Now, the internet service provider can be anyone. It doesn't have to be YouTube, Facebook. It could be the cable service at home you use to access the internet. It could be Verizon or AT&T if you use them to access the internet through your smartphone or your tablet. It's any website, any internet connected app, anybody that's basically allowing people to upload content to their platform. And so if you have a small site that's just starting out, that can qualify as well. You don't have to be a huge business or service. But nonetheless, if you think back to, around 1998 or so, we had a bunch of companies that were launching that didn't have a ton of resources, and the law was designed to give them protection so that they could grow, and so that the internet as a general concept could grow without the companies being stomped into the ground by endless copyright infringement lawsuits. And in that sense, it's worked pretty well. Without the DMCA, we probably don't have companies like Facebook, Twitter, Google, Instagram, these kinds of groups, because they would have just been, devastated by a huge wave of copyright infringement lawsuits. So, is there a cost to this immunity? Of course there is. This is the law. You know how this works. For you to take advantage of the immunity provision, you have to follow a compliance process detailed in the DMCA. And you can go find books and everything else on this process. It is a simple process. Do not be intimidated by it. This is definitely a do-it-yourself kind of area. Now, if you want to hire a lawyer to do it, you can. I'm in California. Feel free to hire me. I'm going to charge you for it, and you don't really, it's probably not the best use of your money, to be honest. There's, pretty standard guides out there as to how to comply. And again, it's not particularly difficult. It may read as a bit complex, but once you do it and you start following the process, it becomes, very simple. So how's the compliance process? Well, if we look at the basics of it, copyright owner out there, he finds his content on your website and it's being used without his permission. He submits a copyright complaint to you, to your agent. Now, this complaint in the verbiage of the DMCA is called a DMCA Takedown notice. It's going to contain certain statements in there, a link to the original content, a link to the offending content on your site or your app, and what have you. Now, he's going to submit it to the DMCA agent. So you're going to have to designate an agent. I refer to him as the secret agent man here. Could be secret agent woman, could be, whoever. But the copyright or the DMCA requires you to designate an agent. The agent is going to be listed in the copyright or with the Copyright Office in an online database that they maintain that people can look at and see. And that agent information is also going to be listed on your app or your website, whatever it may be. Now, the agent, you have to be a little careful with them because their information is listed publicly. And that includes their name, street address, phone number, and email address. So if you're working from home or something like that, you probably don't want to list yourself because, again, that information is public. Do you really want fans or worse showing up at your house? What if you have kids? All those kinds of implications. There are third-party services out there. An excellent one is DMCAagentservice.com. They charge you $70 a year to be the agent. I should know. I own the company, so full disclosure there. But you can also talk to your lawyer. Maybe your lawyer will do it. And there are some other third-party services out there. It's not a big deal. But nonetheless, make sure you have an agent. Make sure that agent is registered with the Copyright Office and listed on your site. Very important. Very important. If you don't take those steps, you're going to lose the immunity. So, complaint comes into your agent. What happens next? Well, your agent's going to process it, give it to you. At that point, under the DMCA, you're going to take down the offending content. Now, this is an important thing to understand that a lot of people mess up. You don't evaluate the complaint or the content. You don't look at it and say, well, do I think it's infringing or not? You're not a judge. Most people listening to this are not going to be trained in the law. This isn't your decision. It comes down automatically. And at that point, you then send a message to the person who posted it saying, hey, we received a complaint, a copyright complaint for this content that you posted. And we've taken it down. Now you have a right to file a counter notice. And so at that point, what's going to happen in probably 95% of the cases is you'll not hear back from the person who posted the content. And the reason being, they probably don't even know there's a concept of copyright. They didn't realize that they were doing something wrong, and they're just hoping they don't get sued. And so at that point, that's kind of the end of it. The copyright owner, you don't have to communicate with the copyright owner. They're going to see the content's down, so they're going to be happy. And the party who had posted it, hopefully they're not getting sued, so they're going to be happy, and you're done with it. It's that simple, really. Now, what if that person responds? What if they say, no, I have a right to use it, or something of that sort? Well, they're going to file what's called a counter notification with you, counter notice, and it's going to contain some certain provisions in it. And at that point, you're not going to evaluate that notice. You're just going to forward that information to the copyright owner. And then you're going to tell the copyright owner, hey, we received a counter notice. Here's the counter notice. And at that point, the copyright owner has 10 to 14 days to go out and actually file a copyright infringement lawsuit against the person who posted the content. Again, not you, the person who posted the content. Now remember, you have immunity. Now, sometimes they'll try and name you, but the court will dismiss you pretty quickly. It's not a big deal. But the point is those two parties then go have at it in court. And after 10 to 14 days, if you haven't received notice of the lawsuit, so the copyright owner, they have their bluff called and they don't actually go file suit, well, at that point, you're going to put that content back up. And again, you can't be sued for that. That's part of the process. You have immunity. And at that point, the content would stay up until you get a court order or some kind of a complaint, an actual legal complaint, a lawsuit that shows it was filed from the copyright owner. And in most cases, they're going to file quickly or not at all. So those are the basics of the DMCA. The DMCA basics they may sound pretty simple, or maybe they sound a little confusing, but they are actually very simple. Once you go through that compliance process, you'd be stunned at really how quick and how simple it is. And complying with the DMCA, it costs you almost nothing. To register your agent, you're going to pay $6 to the Copyright Office. I know, I am outraged as well. $6. When was the last time you paid $6 for anything? And so, there you are. Now, if you use a third-party agent like DMCAagentservice.com, the charge is going to be $70 a year. So again, we're talking peanuts compared to the immunity that you're getting, the benefit from complying with this law. Basically, anybody online that has a website or an app or is in any way running a platform where they allow people to upload content, they want to comply with the DMCA. You just be nuts not to. It's a get out of jail free card. So I would strongly suggest that you look at it, get an understanding of it, and then comply with it. So that's it for the DMCA basics. If you have any questions or comments, post them below. I'll be happy to respond to them. If you enjoyed the video, please give us a thumbs up. If you didn't enjoy it, I feel shame. Thanks for watching. Have yourself a good one.